Hi, Bill Henshaw here again with more of my YouTube current events videos. This is a follow-up to the one I've just done on the Bill of Particulars and the burden of proof the local dumbass has to sustain jurisdiction and venue of the trial court, which they've never attempted to do. Now, what that means is basically this. If they don't reply, that means they've conceded that the court doesn't have jurisdiction. They've also conceded that in effect there's no constitution if they can exercise federal regional martial law rule. They've also conceded the suspension of even the non-statutory federal writ of habeas corpus, aka to the founders and framers of the Constitution as the Great Writ of Liberty, going all the way back to 1215 in the Magna Carta. And they've also conceded that there are no states. And that's Pandora's box, because if they're not in states, now we have structural jurisdictional errors. You're never going to see any goddamn civil rights setting. Attorneys won't even know it or understand it. But if we're in territories, all these judges, aka black robe bastards, have to be appointed by the president or a territorial governor appointed by the president pursuant to the Appointments Clause, Article 2, Section 2. And I'm going to be updating some other of my documents again because I think I can do a better job of it and be more overt about this, because if you can't produce a certified copy of your appointment to the office, you ain't there. You got no authority, you got nothing. Even if the legislature was perfectly in accordance with the Constitution, and trust me, it isn't. But that's the kind of issues that you need to be raising in your case. They're good across the board. Doesn't matter where it is, traffic court, family court, tax court, doesn't matter where the hell you are. If they haven't got judges, and all these judges, by the way, are required to be members of the State Bar Association, and it seems on the surface you would expect they might know the law and actually obey their oath to be bound by this Constitution and the laws enacted in pursuance thereof. They don't. Rarely have I seen a judge that I thought had any idea of what I was talking about. It's happened, but rarely over the course of 5 decades. But the point is that every one of the issues I advocate and that you will be using, at the very least, challenges what I identify as the malignant, malevolent monopoly of the state bar on the practice of law. How can a state bar member, judge, quote unquote judge, possibly be a neutral magistrate and be able to rule on that, exercising the judicial power of either a state or the United States? And by the way, this is not me saying it. Again, the U.S. Supreme Court says that you're required to have a neutral magistrate. Cases Toomey v. Ohio, 273 U.S. 510. It's a piece of 14th Amendment case law crap, but this is one we can argue and say, wait just a minute here. It applies legally a fortiori even more to our cases, given the issues that we're raising. And we'll note here, by the way, that we can't at the moment have any way to get to a jury or a federal criminal grand jury with our issues. That I hope is going to change before the year is over. And I've had cases, my South Carolina case in particular, where my friend back here in San Francisco sent them copies of all of my jury instructions. There are almost 600 of them. And the reason being, I was ready to go to jury trial from day one, but I also knew there wasn't going to be one. And I never got anywhere close to going to a jury trial. And that's one of the reasons, because if you can't get in front of a jury and make your case in front of a jury that has the power to rule on the facts and the law, there's no right to trial by jury. Simple as that. And that's one of the bedrock rights in our Constitution. And again, all we're going back all the way to the Magna Carta in 1215. Trial by jury. Okay, you read Essays on Trial by Jury by Lysander Spooner in 1850. And I may be able to get you a copy of that. Send me an email, youwinnincourt@gmail.com. Also, I'll get you info on my document packets that you're going to love to have, because they're good across the board and very modestly priced. And you get a lot of help from me when you get these. For example, you get complimentary phone consultations with me with the full order. and as much TLC via email as time and circumstances permit, because I know you're going to have questions, just like I did years ago. I didn't get it right away either, but I was a slow damn learner looking in retrospect, but I got it now. So all of that said, this is how good this is. And if they have irreconcilable conflicts of interest, these backroad bastards, they have a sworn duty to make what's called a sua sponte recusal for cause and take themselves off the case. But the same thing can be said for every one of these backroad bastards. They haven't got a single one of them that can rule on our issues. No judicial courts, no judicial process, bill of attainder. Ain't game over. Simple as that. And if you're listening out there to 9 farts, you'll be getting more documents from me demanding that you start doing your sanctimoniously self-declared job to say what the law is, Marbury versus Madison, and take cases like this. It won't take too many cases with bills of attainder to get the point across. All the laws on the books, whether in my hometown of Washington, D.C., whether your various state quote-unquote capitals, they're all bills of attainder. And for a lot more than the reasons I've discussed here, trust me, it gets so much better you can't stand it. This is how much power that we're supposed to have with the Constitution as originally enacted. And that's why it is I'm here 72 years old, and my life is ahead of me because I get it. I understand the perspective. They're not going to beat me. If you study my materials and learn how to do it and teach your children and your posterity, they won't be able to beat you either. We have creator endowed inalienable rights that they cannot do anything about. And this is what we have to stand up and say, wait just a damn minute here, screw these civil rights and all this crap. That's for guardian and ward relationships, better known as master and slave. The relationship we have with government is principal and agent. You do what we tell you to do, not the other way around. When was the last time you saw that happen? And I did in my South Carolina case when I was, and boy, this would be $1 million video because I shut him up in 30 seconds. And the charge, by the way, was practicing law without a license. And I left and I said, well, first thing is I don't practice law. I get it right the first time. And I said it right about like that. And shut him up. And then they wanted to test me for competence to appear as my own attorney. And I said, wait just a damn minute. That's not how it works. The U.S. Supreme Court has ruled, and I gave him the case. Barron v. Baltimore, 7 Peters 243, 1828. Bill of Rights doesn't apply to the states. What the hell are we doing here? They never recovered. That's how good it is, and you don't have to be nearly as good as I am at it. You get to know 3 or 4 issues with some reasonable certainty, you can do the same damn thing because they don't have a clue. Not a clue. So I've done that. I won a recent local case here in California, 14 felonies, and it ended up being a time-served plea deal. And this is with the damn DA and the assistant DA, who were very, very demeaning and condescending to us at the beginning of this case. But when the time came to go to trial, I knew they weren't going to do it there either. It took them a year to figure that out, and we're going to make a hell of a lot of money for all that time this kid sat in jail without any court having any jurisdiction. And you can do the same thing, by the way. Send me an email, youwinincourt@gmail.com. I'll tell you all about what I've developed in that area. It's astounding. And nothing remotely related to civil fucking rights. But 95% of those cases, if you don't know, hit the circular file on the first motion of the government, never to be heard of again. That's not what I do. It's not what you'll be doing. What we do makes a hell of a lot more sense, and we're basically asking the underlying question under all of my issues: do we have a constitution or don't we? If we don't, to the 90 parts, tell the American people overtly, and we can take it from there. If we do your damn jobs, all of you in any department of government, and obey your oaths of office. That would be a real good start. And we get rid of a lot of this crap. And there's more to it than that, but beyond the scope of this video. So that said, and by the way, note too, with my 5 basic documents in the trial court, the BOP, like I say, that's a killer without more. But I've got a 40-page motion to dismiss that they can't answer 2 paragraphs. Okay, a brief on the 14th Amendment that proves it never existed from day one. Its ratification with a capital RAT violated all 6 articles of the Constitution, and I can prove every bit of it. and then you get a conditional acceptance of counsel. In other words, we're saying, okay, if the only people you're going to listen to are state bar association attorneys, we'll accept them with the provision that this is a principal and agent relationship, and these bastards do what it is we want them to do and present our issues. If they're not going to do that, we've not been represented by counsel, and now the 904 have ruled that let each judge know at the start of a misdemeanor case, let alone felony, that no jail time can be imposed though local law permits it when the accused was not represented at trial. Cases Arthur Singer v. Hamlin, 407 U.S. 25, page 40, Judge. So they can't put you in jail, they can't fine you, it makes the laws unenforceable, which is exactly what the hell they are. And the sooner we get to start working on this, the better. And if we do it all together with Americans, Asians, and Africans across the board, quit all this divide and conquer crap they've been doing for at least 150 years and do it this way, all of us come out a hell of a lot better and a lot faster. And we get these bastards off our back. So remember, send me an email, uwinnincourt@gmail.com. I'll send you information and some documents I got to get you up to speed. Like the videos, subscribe, tell your friends, get the word out. We have an unprecedented window of opportunity to challenge these bastards right now. And I want to get the job done before this year is over, one way or the other. Thank you.